But what I do know is there were a bunch of people at the party. A bunch of people got pretty drunk. Karen Reed got upset about something, got in her car in the driveway, decided she was going to go home, and backed out of the driveway. And hours later, the other guests at the party found Karen Reed's police officer boyfriend frozen to death outside. And
what a cold.
I know.
Sorry, I'm just kidding. I'm kidding.
And the prosecution's theory appears to be that when she backed out, she hit her boyfriend and just sped away and left him there to freeze to death. And the defense theory seems to be, no, there's another explanation. He was actually bit by dogs. He froze himself to death. There's a big conspiracy by all the other people in the house. The police department's thoroughly corrupt and inept. And you can't trust the state's theory of this case and convict our client. And she had her first trial about a year ago, ended up in a hung jury. And so now we're back a year later and we're trying her again. This time, I am covering the trial along with my buddy Nick.
So do you have the whatchamacallit, the trial actually pulled up?
I do. It's just it's a ceiling fan. Whoops. It's a ceiling fan right now.
I'll be quiet.
CR 117, the Commonwealth versus Karen Reed.
So good morning. I see all counsel are present. I see all counsel are present. Nobody said anything to
Has she been drinking?
Mr. Clerk about needing to see me, but I received 4 motions over this weekend that I assume we need to at least talk about briefly. Commonwealth's motion regarding defense opening statement. I think the first 2 motions we can do quickly. I'm not issuing an order. Mr. Brennan, the defense knows third-party culprit will not be in the opening. If you think that their opening goes beyond it, you can object. Defendant's opposition to the Commonwealth's request for use of independent readers, because there's an objection, the defendant's motion's allowed. So you will not have an independent reader. Is it fair to say that the 3rd and 4th motions, Commonwealth motion to enforce compliance with court's April 16th ACCA discovery order and the Commonwealth's motion to preclude new expert testimony or alternatively to continue the trial date, that those motions will take a little bit of time, Mr. Brennan?
I don't think I'll be long in my argument.
I think that I need more information on one of them. And I think we'll do that at the end of the trial. I mean, at the end of today, we'll hear both these motions. Mr. Jackson, I did see that a list of text messages, 100 or so, is in your response to my order on Friday. Did you provide the text messages themselves? All right. In light of that and the fact that we don't have time, this juror's been waiting for some as many as 3 weeks now, I'm going to prohibit you from mentioning ACCA in your opening statement. And then we'll deal with this later today. I ordered those text messages and they weren't delivered. So we're going to be bringing the jury in. I'll be in recess for 5 minutes.
On that, I think the court respectfully may be factually incorrect on a key assumption of what Your Honor is ruling.
5 minutes, Mr. Alessi.
Mr. Jackson couldn't give you the facts. I would like to hear the law on that.
That's more than 5 minutes. I'll see you at sidebar. Come up here.
Okay, so what just happened? Because I'm still setting up links that I was supposed to send out earlier.
So there's arguments that the prosecution is concerned the defense is going to make during opening that they don't want the defense to be able to make. And for some reason, this is being settled now, 1 minute before opening statements.
Which is insane. Because, of course, these lawyers have been prepping these opening statements for days now. You know, this is
for more than a year. I mean, this is a retrial. So
right, but so they in the abstract for more than a year, but like really honing down their opening statement, they're going to get up and say today, right now, in a murder case, and the judge is like, okay, well, maybe some of your argument you're not going to be able to say now. This should have been handled days or weeks ago.
And of course, the openings where they frame out the entire battlefield, right? These are the things we're going to prove to you to convince you, jury, why either our client's not guilty or our client is guilty. So pretty important that you be able to set out the frame that is the framework for your entitled argument for the entire course of the trial.
I mean, some would argue that opening statements, it's the most important phase of the trial in some ways, because the way you get a juror to think about this case, about your case, is how you will then present evidence. It is to set their tone and their expectation, but also it's to manipulate their mindset into hearing your story the way you want them to hear it. I don't mean manipulate in a negative way. These people are just going to hear a story. You have a ton of facts on it. And then they're going to decide whether your client goes to prison for the rest of their life. You need to get them in the right frame of mind. You need to get them to be listening for certain things throughout the trial. And this is where you tell them, I'm going to need you to hear this. These facts are going to show why my client couldn't have possibly caused this death, or maybe more appropriately, why the state cannot possibly prove that my client had anything to do with this death. And you're going to need to listen. I'm going to need you to hear about these text messages. I'm going to need you to hear how much these witnesses hated this woman going into this party. She wasn't liked. She's a perfect scapegoat. All of these things to frame the jurors, to frame the jurors' minds and just to get them prepared to listen. It's planting the seeds. It's foreshadowing. It's all of the good dramatic elements of storytelling told right up front in exposition. And to have it interrupted and to have it disrupted at a late hour it's one of the things the state does a lot in the trials that I've streamed. I always say, you tend to not, the judges tend to not like too many objections during opening and closing statements, and you kind of let them go. But you notice the state almost always objects during the ones that we've streamed. And it's pretty frustrating, in my opinion.
Yeah, it's where you set the filter. So every piece of testimony, every piece of evidence can be placed in the jigsaw puzzle in the way you want the jury to do that. Otherwise, it's just random pieces of information.
Exactly. It's one of the elements of lawyering that I think gets overlooked because people have a massive focus on the law, but trial is about a story, and the better storyteller has a better chance of getting the result they're looking for. Because that's how we communicate as humans in general. We communicate by story. And so this is the opening scene. This is the expositions where you meet the characters and where, again, the literary elements that you're used to from Hollywood or from great books happen with great lawyers right now. It is the setup. You're going to see this. I'm going to show you this. And sometimes they do it very subtly, and other times it's overt. The state has no facts and no case here. And here's why. And you're going to hear it. You're going to hear it from the people who were there. In fact, the state is going to bring these people to tell you about it. And you're going to find out that those people aren't telling a good story. I mean, and this is how you prime the pump. The judge sounded like she sounded more tired than me.
People in the chat are alerting us to the fact that we're likely to hate this. Oh, I guess she's back. Okay.
Hate the judge?
Yep.
No.
Jurors, hearken to these indictments.
Hearken.
Karen Reed of Mansfield in the county of Bristol, on or about January 29, 2022 at Canton in the county of Norfolk, did assault and beat John O'Keefe with intent to murder such person. And by such assault and battery did kill and murder the said John O'Keefe and is guilty of murder in the second degree and not in the first degree in violation of Massachusetts General Law, Chapter 265, Section 1.
Based.
002, Karen Reed of Mansfield in the county of Bristol, on or about January 29, 2022 at Canton in the county of Norfolk, did operate a motor vehicle upon a way as defined in General Law, Chapter 90, Section 1, or in a place to which the public has a right of access, or upon a way or in a place to which members of the public have access as invitees or licensees, with a percentage by weight of alcohol in her blood of 8/100ths or greater, or while under the influence of intoxicating liquor, and did so operate said motor vehicle so the lives and safety of the public might be endangered. And by such wanton and reckless conduct so described, you caused the death of another person, to wit, John O'Keefe, in violation of General Law, Chapter 265, Section 13 and a half. 003, Karen Reed of Mansfield in the county of Bristol, on or about January 29, 2022, at Canton in the county of Norfolk, did operate a motor vehicle upon a way or in a place to which the public has a right of access, or upon a way or in a place to which members of the public have access as invitees or licensees, and without stopping and making known her name, residence, and registration number of her motor vehicle, to go away to avoid prosecution or evade apprehension after knowingly colliding with or otherwise causing injury to John O'Keefe, such injuries having resulted in the death of said person in violation of General Law, Chapter 90, Section 24, Subsection 2, Subsection A.5, Subsection 2. To these indictments, the defendant has pled that she is not guilty and for trial has put herself upon the country which country you are, and you are sworn to try the issue. If she is guilty, you are to say so. If she is not guilty, you are to say so and no more. Jurors hearken to the evidence.
All right.
Hearken.
Thank you. I'll describe the law in detail at the end of the case and the elements of these charges. But briefly, murder is the unlawful killing of a human being. In order to prove Ms. Reed guilty of second-degree murder, the Commonwealth must prove beyond a reasonable doubt that she committed an unlawful killing and that it was done with malice. In comparison, manslaughter while operating under the influence is an unintentional, unlawful killing caused by wanton or reckless conduct while under the influence of intoxicating liquor. And leaving the scene of an accident
Who's
after
ever done any
causing
of that?
personal injury or death requires the Commonwealth to prove that Ms. Reed knowingly collided with John O'Keefe, that she caused him injury or death, and then she fled the scene. These terms and the elements of the crimes will be explained to you in detail at the end of the case before you begin your deliberations. Now, please remember that Ms. Reed starts this trial presumed to be innocent. The fact that she was arrested or that she was indicted is not proof of anything. An indictment is just a piece of paper. It just makes an accusation. It is merely a formal manner of accusing a person of a crime and bringing that person to trial in the superior court. But it is only the jury, in other words, you folks, who can decide whether the prosecution has proved its case beyond a reasonable doubt. If the Commonwealth does not do that, then the presumption of innocence alone requires you to find the defendant not guilty. The law never requires a defendant to prove her innocence, to produce any evidence whatsoever,
say
or to
that.
do anything other than attend the trial. This presumption of innocence remains with the defendant until you, the jury, make your determination after listening and considering all the evidence.
Thanks for watching this highlight segment of our full-length Law of Self-Defense live stream. If you enjoyed this content, make sure to give us a like and subscribe for more expert analysis on politics, law, and how to be hard to convict. And to watch the full-length episode of this show, just click right here. Stay safe.